the discharge of the defendant on all the counts, the 15 counts filed against the defendant. And the court, in its wisdom, now reviewed all the charges and discovered that with the exception of 7 counts, about 8 counts appear to be similar, and those charges were struck out. Now, it would be also understood that in the argument of the defendant, the account that is reflected in the charges, when you go to the charge, you get to know all the counts. But all the counts relating to terrorism are really sustained by the court. And make heavy weather on the issue of rendition, and the court bluntly said that rendition in this situation is allowed, because rendition in criminal law, in criminal case, is allowed. After all, the defendant is under bench warrant, and anywhere he is seen, the law allows him to be taken and be forcefully brought to court, and that was what exactly happened. And again, with respect to membership of IPOC, which he denied, it was the argument of the defendant that the matter is on appeal on whether IPOC is a proscribed organization under the Nigerian law or not. The court also emphatically said even though the issue is on appeal, but what is in place is that IPOC still remains a terrorist organization within the confines of Nigerian law. And immediately thereafter, they moved another application for bail again, which the court ordered that both applications be taken, and arguments were preferred. And it was also in their argument that NNAMDI KANU had never flouted any of the conditions of the bail. And we have argued vehemently, showing to the world, showing to the court that he has actually flouted all the bail conditions. And that was the reason why the court has ordered for his revoked bail and ordered for his arrest. And it was also our argument that what we should be talking about is contempt of court, not even issue of bail anymore. And we are awaiting the response of the court on the next adjourned date, which the case is now adjourned till the 17th, 18th, and 26th of May 2022 for ruling.
If you start information, then the rumor mill will become very tight, and things will begin to change. You have to cover in my home, in my country, from you, near the cover is Ono Ayolaza Buyuko. Lord has so more. What does it mean? He who was not present when in fact he goat was butchered, we argue later that a fetus must have been removed from his tummy after it had a big tummy. In other words, seeing is believing. You don't hide information. So when you prevent the media from covering it, then it may lead to generation within the rumor mill of things that never happened, which again jeopardizes the fair trial of an accused person, even of the prosecutor and even of the judiciary. In terms of witnesses attending, I have no problem with witnesses being screened off. That is good to safeguard the interest of the witnesses and the fact that you refer to them as A or B, said by them. That's safeguarded. That is a very wise decision. Safeguard witnesses, screen them off. Or if you want to use Zoom, fine. Although that is subject to whether when you use Zoom, whether cross-examination can't also be allowed in that method, or whether the court can set to watch the demeanor of the witness. But I am particularly, I'm not therefore much against the issue of shifting the venue to a more convenient place. That is fair enough. I'm not against the issue of screening of witnesses. That is fair enough. But I'm against the issue of making it look like a secret trial, as if a trial is like a gathering of witches and wizards in a coven. It should be a public trial which the whole world can watch. Then when you come here, you can screen out the people and decide on how many people can attend. The same way that we have been doing it. I believe that because of that, by the grace of God, I'm going to challenge some portion of the new practice direction as being unconstitutional and against so many sections of the Constitution of Nigeria, which is the run-on Nigerian law, which I've referred to at different fora as the Oba, the Eze, and the Emir of Nigerian law, the hierarchy of law, the run-on, the first Origo, who will challenge those sections.
Thank you, sir. Yeah,
That was the voice of the lead counsel of IPOB leader NNAMDI Kanu, who has addressed pressmen here. Points to note are that the trial justice Binta Nyako has quashed 8-count charge amid the 15-count charge leveled against NNAMDI Kanu. And followingly, the defense team theretofore submitted an application for bail on behalf of NNAMDI Kanu. So that is the situation report. Hence, the court adjourned for this very application, hearing this very application, on the 18th/26th of May 2022.